Lockout. A lockout can be declared under the following, I told you already. If it is preceded by illegal strike and apparent danger to property and personnel of any company in the establishment, you can always declare lockout. And where you anticipate and apprehend that sabotage will be there and then some other things will be there and any assaults, etc., there means then always you can declare a lockout. It can be justified. Here also the lockout can be prohibited by the government under section 23. This is also available. So normally it has to be justified in terms of all these things. So this is exactly what is there. So of course I told you already saying that whenever it is prohibited, the issue has to be referred to the state government for reference, the reason for that. And now here there are certain procedures in the sense that how the strikes has to go, how the strike lockout will be going and all that. For example, in public utility services where I told you, the strikes without giving a proper notice, if they go, it is a illegal strike. If it is commenced before the expiry date of strike, again it is illegal strike. During pendency of the dispute before any conciliation, Labour Department, it is there, then again it is a illegal strike. Similarly for management also, under section 22. If they don't give 14 days notice, again it's illegal. If it comes before expiry of lockout, again it's illegal. During pendency, again it is going to be illegal in case of public utility services. In case of non-public utility, just like any other establishment, non-public utility services, the strikes are breach of contract. What do you mean by breach of contracts? See, there may be provision in standing orders saying that the worker shall give 14 days notice. Or whenever you sign a settlement with the union, probably you may have a clause, worker shall give 14 days notice. If it is others called a breach of contract, if you violate it, again it's illegal. And again during pendency of any dispute, if there is a pendency of dispute before the labour court, conciliation, if the people go on strike, again it's a illegal strike. So if supposing the settlement is in operation, and when the settlement is in operation, if they go on strike on an issue already covered by the settlement, then again it's illegal strike. So let's say for instance the payment of a special allowance is already governed under the settlement, but they can't raise an issue of again special allowance during currency settlement. On that they can't go because it is covered the settlement. Similarly, in the case of lockouts also. Now, go slow. This is one thing. It means that persons, instead of going on strike, they concertedly, what they do, they slow down the production, slow down their activities. This is a very common thing what we see everywhere. Suddenly they brought the production by 20%, 30%, 40%. And actually there is no definition of go slow under the ID Act. There is no definition. But it is a misconduct under the standing orders. And also it is an act of unfair labor practice under the Act. One can take action. So, but there is no definition of go slow under the Act, but this is the spirit of it. In fact, Rajasthan is the first government to define go slow. Now, you can have a look at it. The same thing what I have told you, what I just explained to you, same thing, Rajasthan, state of Rajasthan, first government to define a go slow. So, this is an interesting as far as go slow is concerned. Now, here, the go slows are taken very seriously by the court. In fact, in the case of Sugar Mills, Bharat Sugar Mills, Rajit Singh, and the Supreme Court has clearly very said, look at the words, deliberately delaying production by workmen pretending to be engaged in the factory is one of the most pernicious acts. It will not be fair for to call this a dishonest activity. So this is a very, very serious thing. So go slows have been dealt here. Now next we come to layoff and retrenchment. Now this is a very common thing which we normally discuss about layoff and closure. Now there are two chapters under this act. One is called chapter 5A, which applies to people in establishment employing 100 or less workmen. This is under chapter 5A. And chapter 5B is people in establishment engaging number of workers 100 or more, then it comes under chapter 5B. Now, chapter 5C is the what you call layoff compensation. I told you already in the beginning. Layoff compensation is is calculation is only basic wages and dearness allowance, only two things to be taken into account. They are not entitled for layoff compensation supposing the workmen have given alternate work, or they use substitute work, or they put into some other department in the same area, and if the people refuse to go there, then they are not entitled for layoff compensation. Then section 200, it talks about retrenchment. What do you mean by retrenchment? This is a very, very interesting and important issue which we please bear it in mind, very important. The definition of retrenchment says termination of anybody other than for a misconduct. Any termination is a amount to retrenchment. This is a very, very tricky thing. Just here, other than a punishment. Suppose you dismiss a person after conducting inquiry, then it's not a retrenchment. Then, if a person is voluntary retirement, we introduce a lot of voluntary retirement scheme, then it is not retrenchment. Retirement or superannuation at the age of 58 or 60, then it is not retrenchment. Termination of service as a result of expiry of the non-renewal of contract. Supposing you engage a person for 1 year and automatically the terms comes to an end at the end of 1 year, then it is not a retrenchment, because if terms and conditions stipulates that after the expiry of this period, automatically it ends, it is not a termination. Termination due to continued ill health. This also, it is not a retrenchment. Now, subject of retrenchment has been major discussion all through since 1976. In one of the most important thing is that in the State Bank of India, Sundur Moni, in the Supreme Court, they have made a landmarking judgment. Here what happened was that this person was appointed on a periodical basis, engaging for 6 months, give a break, again or engage him for 6 months, give a break, again you engage him for 6 months. It is an artificial break given in course of time, blah blah blah, everything. And at the end of this one, then this fellow raised the issue. Then the Supreme Court said that it is a artificial break, is nothing but a termination without proper cause, then it amounts to retrenchment. So this is a very, very important thing. So termination of service for any also means what all termination otherwise amounts to retrenchment. So this should be very, very careful on this issue. In fact, in DK Yadav versus JM Industries, I can tell you, see, normally, we have got a clause in the standing orders or in the appointment or saying that if you remain absent for more than 10 days, more than 8 days consecutively without notice, you'll be considered as you are lost of lien in the job, and automatically your services stand terminated, or you consider that you abandoned your employment and you're gone, then it's so again here the Supreme Court has said, even in such cases, if you don't conduct an inquiry even before you invoke the clause, then it amounts to retrenchment. It is bad in law. So friends, please keep it in mind. Just because the letter of appointment says automatic termination, just because your understanding order says automatic termination on expiry of due to unauthorized absence, etc., etc. If you don't issue show cause notice, give an opportunity for him to hear on, have a proper inquiry and then dismiss, this amounts to retrenchment. This is exactly what the Supreme Court has said in the case of DK Yadav and JM Industries. Please bear it in mind. I think that due to these are all the different cases have been held. I told you already. Here also same thing. Supposing specific clause in the agreement, in the letter of appointment, and if it is extended for a limited period and then this one, then it will not amount to retrenchment. So this we have to look at. Supposing in the letter of appointment that do not stipulate the reasons, then what happened? Difficult to hold that it is not retrenchment. So always you must mention that even the letter of appointment, whether a temporary or contract, you must specifically mention the period of employment, and specifically mention that on account of expiry of the terms of and expiry the period of this one, automatically the employment ceases. You should mention that. Then it will not amount to termination. Then you are very safe. Otherwise, this becomes a very this is exactly what I said. Artificial breaks given deprive women to attain permanency in case of Delhi Finance Corporation the Labour Court of Delhi has handled like this. So we have to be very careful on account of these things. These are some few decided cases. Rakesh Muni versus DTC, again Delhi High Court, here also same thing. We should keep it in mind. Now chapter 5A, we come to retrenchment. Chapter 5A, layoff, retrenchment and closure. Chapter 5A, here you can easily carry out the layoff, retrenchment or closure without seeking the permission of the government. There is one benefit given, that's the only thing. But of course, I told you already, retrenchment, it has to be preceded by retrenchment compensation. Closure, of course, you can pay compensation later. Layoff, again, you can pay the compensation later, but you need not worry about permission of the government. You can easily do, but you have to substantiate the reason for this. It should not be a malified reason. It should not be a vindictive reason. That should be very, keep it in mind. It should be a bona fide reason. Then you can lay off without seeking permission. But if you are more than 100 people in the organization, then you need to take permission of the government before layoff, retrenchment and closure. This is very, very important. This is exactly what the employees are fighting for, saying that this restriction has to be removed, but in the new Labour Code, they have increased 100 to 300. That's the only small relief has been given under the new code. Now here also I told you already, retrenchment compensation, payment of compensation precedent, I told you already. Then 1 month notice pay you have to give it, that's very much. And important thing is, you have to follow the rule, last come first go. This principle you have to follow. You have to follow this, then you have no problem whatsoever in retrenching under chapter 5A. In the chapter 5B also same thing, but after the government gives you the permission, otherwise you can't do. Then closure also same thing, there is no doubt about it. And of course certain things are exempted. For instance, construction of a building, it's for a limited period, it's a closure, so no worry about it. Roads, canals, dams, etc. They are all periodic based projects, then the closure clause doesn't apply here, then automatically one can close it. So here also what happens is under chapter 5A, I told you already that these are the conditions applicable for closure, then you can do it. But in the case of chapter 5B, then you have to serve a notice to the government, at least 90 days prior notice you have to give to the government. The moment you serve the notice to the government, the appropriate government will call for a discussion with the management, they will thoroughly discuss and they have to pass an order. If they have to pass an order within 90 days of the receipt of notice. If they do not pass any order within 90 days, the closure permission or retrenchment compensation is deemed to have been given. That's the kind of thing. So this is one thing. But normally what happens the moment you go to Labour Department to put up the case, the unions will not keep quiet. They also hurry up the entire thing and see that the permission is given or not given. If it is not given, either party can go to the higher authorities like the High Court. They can question the bona fides of the order passed by the government either way, either in favor of the management or may not be in favor of the management. You have to have a right to go and appeal. So this permission is a must. So this we must always bear it in mind. Without permission, it is not possible at all. This is exactly what I told you. The compensation also in case of closure. Chapter 5B layoff compensation, I told you. It had give notice of layoff. Time limit is 60 days. Then the government has to hear within 60 days and pass on the order. Of course, the reason for layoff, as you know, it can be fire, flood, excess inflammable explosion, and employers seek approval. But sometimes what happens, you may ask a question saying that, sir, there is a sudden fire, how do I ask for notice? If there is a flood, how can I ask? There is a natural calamity. Can I ask permission? What law says is that you first do that, lay off, but apply for ratification of the reasons. Then the government will go into details reasons, and if your reason for layoff is justified, they will accord the permission. If the bona fides are not clear, then they will say your layoff is bad, then you full pay back the wages. This is exactly what is going to happen. So chapter 5B under Department of Closure and Retrenchment Compensation, I told you already, you have to give a prior notice of 90 days, then you have to hear, then based on the reasons justification given, the government can give the permission or not give the permission for retrenchment and closure. But this is our mandated proceeds in the rate of retrenchment clause. Now in the new code also, the same thing have been incorporated in the new code also. It means that only liberty is that the limit has been increased from 100 to 300, that's all. Otherwise, all things remain unchanged. It means that you have to take the prior permission. Only thing is Chapter 5B is not applicable to IT, ITES and commercial establishments. That is the only relief. Where Chapter 5 is applicable to all. It means that even software companies, they can lay off or retrench anybody, even though they have got more than 100, they can, because this chapter is not applicable to IT, ITES, because here the definition and understanding have been defined. It says only factory, plantation and mines, only 3 things. Otherwise, everything is it is not applicable. That's the only thing. So, here's one thing. And secondly, now the government has put some conditions on employees not affecting changes, because what is the intention of the government is, suppose there is a dispute pending and the company wants to take revenge on the union or revenge on the worker because you are given, I will teach you a lesson, and drastic change in service conditions if you make, it is not permitted. Just because people have created a problem for you, it doesn't mean that you can take revenge on them, change the service condition, change the shift, allocate the whole thing. All these things is completely prohibited. Unless you seek prior permission and approval, you can't alter the condition. Similarly, what happens, even in the case of dismissals, when the dispute is pending, in dismiss also, if the worker is concerned and connected with the dispute, then you have to conduct an inquiry, no doubt, then hold him guilty, no doubt. Then before you pass the order of termination, you have to go to the authority and seek approval for dismissal. If the employee is concerned and connected with the dispute pending. But in case of other things, where dispute is pending and only the employee is interested in the dispute, in such case what happens, then you have got to conduct an inquiry, do everything, you can pass the order, dismiss him. At the same time, simultaneously file an approval before the authority for your approval of the action taken. It means that, sir, I have dismissed him, I request you kindly to approve my action of dismissal, because under section 33(2)(b), this is very must. Now here what happens is that on the day of issuing the letter of termination, you have to issue 1 month salary and dismissal order. At the same day, on the same day, you have to file an application before the authority. Simultaneous action. If they even delay by 1 day, your action will be ruled out by technically it is bad. So be very careful on that. Now next question is protected workman. So here also the protected workman, the status has been given in the sense that section 33(4) also to be declared as a protected workman. Here 1% of the workmen or minimum 5. Here what happens, if the union gives you a letter declaring, sir, please declare the following as the protected workman, since there are office bearer committee members, and if they submit the application before 30th April, then you are bound to consider it. Even delayed by 1 day, it is technically not correct, you can reject it. Now what are the benefits available for protected workmen? The only protected workman is that for misconduct, if they commit any misconduct, then you have to seek approval. I told you already, you have to seek approval of the you have to seek permission to dismiss them. In case of protected work, you say, so let us say for instance, union secretary is there. Now he is declared the protected workman. But what he does some mischief, in this sense he assaults a manager in the shop floor, and you conduct an inquiry, you hold an inquiry in line with the principles of natural justice, and everything is ready, and you want to dismiss him. Before you dismiss him, you have to file an application before the authority. Sir, he is a protected workman, he has committed this, I have conducted an inquiry, and in principle lines of principle natural justice, and I request you to kindly approve the action to be taken. Then the court will go into details, everything, and if the case made out by the management is correct, then they will accord approval. Then you have to pass the order of dismissal. That is the only benefit available for protected workmen and nothing else. Then I told you already about the section 33(2)(b). I told you, explained you already. If a person is concerned in the dispute, you can dismiss. But only thing, afterwards you can seek the approval. That is the only thing. This is a simultaneous action. All three things are simultaneous action. It has to be done on the same day. That's very important. And 1 month notice also you have to pay very clearly. Even if there is ₹1 shortage, it is a technical mistake, and the court will say take him back. It's very, very careful. So you should be very careful and cautious in exercising these rights. But there is a protection given. I told you already, in case of protected workman, these are the exact things that just because he is a union leader, can I transfer him to some other place? Yes, you can transfer it, provided your service rules permits it, and with a bona fide reason. If it is a bona fide regular reason, you can always do it. Then suppose you don't want to do with a bona fide reason, then what happens? Then unless it is a violation of this section 33(a)(b), then it becomes not legal. This kind of thing. So here the simple thing is that 33(2)(b), when you file an application, the inquiry should be fair and proper. This is a prima facie case for dismissal based on legal evidence. Employer has come to bona fide conclusion, is found guilty and not victimized, and you have to pay all these things. Then what happens? Your approval application will be a bona fide withdrawn, and the court has got a limited power. Either they have to say yes or they have to say no. That's the only thing. But they can't go into the merits of dismissal, in the sense that no, he has done a small mistake, don't dismiss him, give him some other punishment. They have no authority. They have to say approve, yes or no. After the dismissal over, the workman can again go and agitate before a labor court. That's a different issue. But here, the only question, yes or no, is the only thing the court has to, provided you satisfy all these 1, 2, 3, 1, 4 conditions. So just keep it in mind, these are the things available. So here also jurisdiction is limited character. I told you already. The domestic is not defective, is not defective, then they have no reason to interfere in this matter. They cannot do this. So here also, if everything is fine, the court also is helpless. They cannot do anything. They have to say yes. So if the inquiry is not good, then you can always plead for to give an opportunity to adduce additional evidences. You can always do that. The court has to say yes for that. So you conduct an inquiry and dismiss him and seek approval of the case. Then when you file the memo, when you file the written statement, at that time always you should include a clause saying that management should be permitted to lead evidence if required. You should put a clause. Then the courts are bound to accept it, and you can lead additional evidence and to prove your case that the whole inquiry is in line with the principles of natural justice. So just have this in mind. This is the spirit of the act. So these are some of the judgment I told you. I can go through this. Bricks India versus ALC, then Sunil Kumar versus Vittala Supply in Calcutta High Court. These are the some 2-3 things. Now we come to the last chapter of unfair labor practices. Unfair labor practices, because it is natural, because what happens, intentionally the management may do some unfair labor practices, or intentionally the unions also may do some unfair labor practices. It's bound to happen. So it has been listed down. So anybody violates it, one can complain to the authorities and then come to this. On the part of employers, what can be? Here, supposing, if you interfere with the union formation and coerce them, or come in the way of their forming union or forming organization, you interfere in their affairs, then it is unfair labor. Because as you know, the formation of trade union is a fundamental right of anyone. So if you coerce, if you do anything, then it's against the interest, then it's an unfair labor practice. And here also, suppose you give financial aid to a certain union to support, then it again it's unfair practice. Suppose you give financial aid to employees, say, no, don't form a union, I will give this money, don't form a union, then again it's unfair practice. These are certain, to encourage or discourage members of union. Again, I told you already. Attempts to break the strike through various means. When the strike is there, we adopt a lot of methods to break the strike, all these things, then again it's unfair labor practice. To recruit workmen during strike, which is not illegal, and in acts of threats and violence. So this is also illegal. Then failure to implement the terms of settlement or award. Somebody agreed for certain issues in the settlement, and if don't implement it, if they don't implement certain clauses, then again it's unfair labor, because you already agreed for it. So you can't say I will not implement. If you don't implement it, then it amounts to unfair labor practice. Then this is very important, friends. Let's have a look. To abolish the work of regular nature being done by the workmen, and to give such work to contractors to break the strike. So this is another peculiar thing. Normally, this happens in the industrial unrest. This happens. So if you do this, again it is unfair practice. Your intention is to break the strike. What do? You engage contract labor to do the regular work with the intention of breaking the strike, which is not correct. So it is unfair practice. Transfer the workman with malified intention. Purposely I transfer. I don't like him, I transfer him. Because he is union leader, I don't like him, I transfer him. No, with malified intention we do it, then again it's not a not fair one, it's unfair. To show favoritism or penalty. I favor him or I want to penalize him. Unfair thing, unjustified thing, it will not hold good. The employee badlis and temporary over a period of long time to deprive regular employment. Somebody you engage casual labor for months together, years together, with a view to deprive them the regular work, because you make the casual workers to do regular workers on the production related areas, and keep them as casual or temporary over a period of time, then again it's your intention is not to make him permanent. So that intention is called unfair labor practice. So these are the kinds of things. And refuse to collective bargain with recognized union. When there is a recognized union, you have to bargain. And supposing you say, I don't want to bargain with the recognized union, again it's a unfair labor practice. On the part of union also, something have been listed. Actively advise, support or instigate in illegal strike. If the workers and unions do it, then again it's unfair labor practice on the part of them. Then coerce the workmen to exercise their right of self-organize. This is one thing. Then picketing in the manner non-striking workers. What we do, what we see, they enter the workplace and then force others not to work, and then they form a group and they won't allow anybody to work, and they don't allow any managers to come there or anybody to come there. All these things, then threats, intimidation, all these things happens. Then what happens? It's an unfair practice on the union. One can take action. And if they refuse to collectively bargain with the employer, supposing the management says, no, you come to me for a discussion, but no, will not come. Collectively, those will not come for a discussion. Then again, it's a unfair labor practice. Then willful go slow and squatting. This is a unfair labor practice. I told you already when I was talking about go slow. Willfully going slow and squatting in the premises. Just finish the work and squat, sit in the premises. If the shift is over, just sit and squat in the premises. These are all unfair labor practices. Then Gherao managerial staff. This is a normal thing what we see. Gherao the managerial staff, they will not allow to go out of the chamber itself. Then Gherao is a this is also a unfair labor practice. In fact, these two things have been added in the labor code also. They added this as one of the unfair labor practices. The demonstration in the residences of employers and managerial staff. This also many times it happens. They go and demonstrate before the MD's house or chairman's house or general manager's house or manager's house. They do a protest, they go outside and do it. Again, it's unfair practice. Then you willfully damage the employer's property. Purposely, when they're inside, damage, sabotage activities. All these things, what happens? They are all unfair practices. And this one. And acts of violence and force. You see, nowadays, of course, we have seen a lot of violence, acts of assaults on managerial people and all that. So those are all acts of unfair labor practice. One can take it forward. So friends, I have come to the end of the presentation. I thank you all. And if you got any doubts and clarifications, if you want more details, please send me an email on this email ID. I will be glad to furnish all the details. And moreover, the moment we'll have an interaction web meeting after 2 weeks. Then in web meeting you can always have a discussions along with the open. I will clarify all the doubts. If you got the explanation to begin, I will explain to you all these things. I will do it. So thank you all. Wish you all the best. Thank you.